Well, hello, my name is John Watts, and I want to welcome you to our webinar where we talk about consumer protection questions. Today is August 21st, and so as we do typically every Friday, we're going to answer some questions. And I have 5 questions, one of which is on foreclosure, and then 4 of the questions relate to judgments. We've been getting a lot of questions about judgments, and so we'll go ahead and handle those this week. So just a little quick reminder of how we do this. These are questions that come from you, or come from people that call our firm. Some people will leave us a comment on our website, alabamaconsumer.com. Or if you live in Alabama, you can call our firm 205-879-2447. And you can also leave a comment or send a private message here on YouTube. So however you want to get the question to us, that's fine. And we just keep track of what questions we've received during the week, and then we try to answer those on Friday. So our first question, and this is related to foreclosure, is what is a deed in lieu? And so let's take those words. So a deed is just the ownership, you might say, to your property. And then we say in lieu of, or instead of. Well, instead of what? Well, instead of a foreclosure. So it's as if I take my deed and I say to the mortgage company, you know what, instead of you foreclosing and you taking the deed, how about I just hand it to you? So you might think of this almost in a car context as like, instead of a repossession, you voluntarily take your car to the dealership or to the bank. And so there are different ways that this can impact you as far as credit reporting, deficiency. Deficiency is if you owe this much and the bank sells a property for this much, do you owe that difference? Sometimes in a deed in lieu, we make an agreement and it's all got to be in writing, got to have all this written down. Will they come after you for a deficiency? What will they put on the credit reporting? Sometimes they call it a foreclosure. You just need to know exactly what the deal is before you decide if this is a good approach. This is really kind of the broad level or top level is called loss mitigation. And then underneath loss mitigation, we go down and we have loan modification, forbearance, a short sale, other things, including deed in lieu of foreclosure. So if you're talking to your mortgage company or maybe a real estate agent says, oh, you can do a deed in lieu, just understand that what that's talking about is you hand the mortgage company the deed in lieu of, instead of them foreclosing. And sometimes that's appropriate. Sometimes there are a whole lot better options than that, but that is one option for you. All right, so our next question is, will bankruptcy override a judgment on my credit report, and which hurts me the most? Well, let me kind of take that a little bit out of order. So is it better to have a bankruptcy or better to have a judgment? Well, it depends. Both of those are negative on your credit report. We look at the timing. So generally, anything that happens bad here, the next day, it has the most impact. The next day, it starts to slowly go down. Now, really, I mean like the next month or the next 6 months or the next year. Here's the worst that happens, and then it starts declining because, and that makes sense if you think about it. If somebody failed to make a payment, would you rather that have been 6 years ago or 6 days ago if they're wanting you to loan them money? So we do look at the timing of it. Generally, a bankruptcy, and I assume what's meant here is a Chapter 7 bankruptcy. It just wipes it out. It's also called a straight bankruptcy. And so a bankruptcy will normally wipe out the judgment so that you do not owe the judgment anymore. In terms of, which is worse, well, let me give you this example. If somebody says, I think I'm going to have some judgments against me, I'll just wait till I get the judgments that I'm pretty sure are coming. And so that'll happen now, and then I'll file bankruptcy. Well, that's fine. But what if you can file bankruptcy before the judgments? Well, see, if you do that, a bankruptcy stops a lawsuit, and there are exceptions to this, but normally that happens. And so if that debt is wiped out in the Chapter 7, then there is no judgment. So sometimes it's a timing issue of, do I go ahead, pull the trigger, file bankruptcy? I think bankruptcy is very rarely appropriate, but it can be appropriate. So do I do that now and then I don't ever have a judgment? Or do I get a judgment and then after the judgment, I've got to file bankruptcy? So in a perfect world, we would rather just have a bankruptcy and no judgments. But if you have a judgment, then a bankruptcy can certainly help by getting rid of that debt. Now, as far as the impact on your credit score, it just really depends. There's a lot of factors. Are you discharging a car loan judgment? Well, that might have more meaning to an auto dealer or auto finance company than if we're talking about a $5,000 medical bill or debt. So it just really depends. Now, the first part of this question, will bankruptcy override a judgment? I assume what was meant there is if I have a judgment, $5,000, and then I file bankruptcy, does that make this go away? Well, it doesn't make the actual judgment go away. But what it does is it means you owe zero on that judgment. So that debt, that liability is gone. Now, you have to be careful. There's a judgment and then there's a lien put on your property. Well, that lien doesn't just automatically go away because you file bankruptcy. So sometimes you have to do something in bankruptcy court it's called avoiding the lien or getting rid of the lien. And so that gets into some complicated stuff, but just understand that normally a Chapter 7 bankruptcy will wipe out a typical judgment, and a bankruptcy and a judgment are bad on your credit report. I don't know, though, that it's necessarily worse if you have, let's say, 3 or 4 judgments and then you file bankruptcy. Yeah, it's bad to file the bankruptcy, but getting rid of those judgments can be very helpful too. So anyway, lots of questions to ask if you sit down with a bankruptcy attorney about what will happen with these judgments, what happens to any liens, and what does this do to my credit report. But I hope this has at least given you some information about this. All right, our next question is, how long can somebody collect on a judgment? So give you some kind of general rules. In Alabama, if a judgment happens, let's say in 2015, they can collect on that really for about 10 years. And then even after that, they can do something called renewing a judgment, maybe for another 10 years. So sometimes we get people that call us and they say, hey, there was a judgment against me in 2007. And that's 8 years ago because it's now 2015. So I think statute of limitation is run on that. Now, statute of limitation is how long does somebody have to sue you? So here's the thing we did wrong, broke a contract, ran a red light, whatever it is, we did something wrong. Now there's a period of time to sue us. That's statute of limitation. But once that suit's filed, and if it was filed within the right time, then we don't care about statute of limitation anymore. That lawsuit could take 20 years. Very unusual, but it could take 20 years. Well, that's fine. They get a judgment. Now they can collect as long as that judgment is valid. So just understand statute of limitation, because we get a lot of these questions, that's the time period to sue in the first place. But then after that, statute of limitation does not apply. Okay, so our next question is, do judgments really double every 6 years, or does it just seem that way with interest? So let's talk about it. We get a judgment. From that point forward, that judgment is making interest. Now, it depends on what the interest rate is. It used to commonly be 12%. Now it's typically a little bit lower than that. But if somebody sued you on a contract and they can prove what the interest rate of that contract is, it can be higher than that. So imagine you have a credit card at what, 29% interest, and they get a judgment. It could be a really high rate of interest. They normally don't ask for it that high, but that's possible. So do judgments really double in 6 years? Well, there's no law that says every 6 years you will double. It's just that interest. So how do we figure out how quickly something will grow? Well, there's a rule of thumb called the rule of 72. Okay. And that just says you take the interest rate, whether we're talking about an investment, a debt, whatever we're talking about, you divide that into 72. So if it's 12% interest, divided into 72, 6. So in about 6 years, that will double. So let's say it's $5,000 judgment. 5 years later, it's 10. Or I'm sorry, 6 years later, it's $10,000. Then another 6 years, that 10,000 becomes 20. Another 6 years, that 20 becomes 40. It just keeps growing and growing and growing. That's the power of interest. Now, if it's 6% interest, it's going to take 12 years to double. If it's 36% interest, it's going to take about 2 years to double. So it's just a matter of that interest. And where people can get burned on this is maybe they allowed a default judgment to happen, $5,000. And that's 6 years ago. And they go, well, yeah, okay, I think I need to pay this. So, I'll go pay them something less than 5. And the collection lawyer goes, well, wait a minute, it's now $10,000. They go, no, it can't be. Yeah, there's interest. That interest accrues. And so be very careful about that. And, if you are in a garnishment situation, and so here's a judgment, and then they're garnishing your wages as you go forward in time, you want to make sure that you're considering what is the impact of the interest. Because sometimes people, again, we'll use our $5,000 example, and now they've garnished me for $5,000. I go, oh, good, I'm done. And then 4 years later, I get a nasty letter from the collection lawyer saying, hey, you owe us $2,000. I'm like, what are you talking about? It was a $5,000 judgment. You garnished $5,000. They go, yes, but you forgot about the interest. So you just need to be careful with this. Okay, our next question is, I think actually it's our last question. Can I be garnished in a state other than where the judgment was entered? So give you a typical example. Let's say that you're sued in Georgia, and it's a car wreck. It's for an old credit card when you live there, whatever it is. And they get the $5,000 judgment against you. And now you live in Alabama. Can they come here to Alabama to stick their hand out and say, I want money from your bank account or your wages? Well, they can. They have to go through a few steps first. Let's take that example. So you're in Georgia, and I don't know what the rules in Georgia are, whether they can do wage garnishment, bank garnishment. Assume that they can. They get a judgment against you in Georgia, then yeah, they can garnish your wages in Georgia and hit your, but to just come over is not valid here. They have to do something called domesticate the judgment. So what they do is they say, hey, Alabama court, over here in Georgia, we have a judgment, and now we're bringing it here for you, in essence, to bless it or to say, yes, this is now valid in Alabama. It's usually not a real in-depth process. There are some defenses, some arguments you can make. Maybe you didn't get served over here. And it gets a little complicated. Do you go fight that over here in Georgia, or do you fight it here in Alabama? Different strategies based on exactly what's happened. But the point is, they get that judgment out of state, they can, if they jump through the proper hoops, go through the procedures, they can garnish that here in Alabama. We see this sometimes for $1,000 things. We've seen it for seven-figure judgments where they're coming after you from another state. So give you some quick thoughts if you are in that situation. I would definitely recommend, figure out what happened in that other state. Because sometimes people, all of a sudden they get this letter or this memo from HR and it says, you're being garnished. Like, what? I've never been sued. And then they, find out it's something in Georgia. And they call a court in Georgia and go, oh, yeah, you were sued 6 years ago and we got a judgment against you. You're like, I've never been sued in Georgia. I never got served with the papers. So you do have to look at that to make sure it's a valid judgment. But assuming it's a valid judgment, then yes, they can take it from Georgia to Alabama, vice versa. So those are our questions for today. Just by way of summary, we talked about what is a deed in lieu of foreclosure. Will a bankruptcy override a judgment on my credit report, and which will hurt me or affect me the most? How long does somebody have to collect on a judgment? Do judgments double every 6 years, or is that just the interest? And then, can I be garnished in a state other than where the judgment is located? So hope that that's been helpful to you. If you will just leave us a comment below, or you can go to our website, alabamaconsumer.com. Or if you're in Alabama, you can call us 205-879-2447. Ask to speak to Carolyn, and she can definitely help you out. And also, if you just have a question, she can pass that along to me. And what we do, just so I can explain about calling Carolyn, when you call the firm, a receptionist will answer. Just ask for Carolyn. She does all of our phone work. So we try to kind of protect Carolyn from having to deal with court issues and drafting documents and things like that, so that she is completely available for talking on the phone. So whether that's a potential client or an existing client, we have clients from 5 years ago that come back to us. So whatever the situation is, she's kind of your first point of contact, and then she'll set you up with a phone call or an in-person meeting with me if that's appropriate. So just let us know if we can help you in any way, and I appreciate you watching this. Okay, have a great day. Bye-bye.